Hello friends, in this part we will try to understand a very important element of a contract, that is consideration. So what we will discuss in this part? First of all, we will understand what is the exact meaning of the word consideration, what we can call something as a consideration. Then we will discuss what are the various legal rules about the consideration. What will happen when an agreement is without consideration? We will talk about validity aspect of such agreements. And finally, we will discuss something about doctrine of privity of contract and what are the exceptions of this particular doctrine. This is going to be our overall area of discussion in this particular part. First of all, let's try to understand what is a consideration. Consideration is one of the essential element of any valid contract, and we need to keep this thing in mind very clearly, that an agreement which is without consideration is void. Though there are certain exceptions to it, but in majority of cases, if there is no consideration, the agreement is going to be treated as a void agreement. Say for example, Mr. Raja promises give rupees 1000 to Mr. Hari, for which there is no consideration. Now as per law, this is a void agreement, meaning thereby later on Hari cannot demand legally rupees 5000 from Mr. Raja. He cannot say that since Raja has made a promise, Mr. Raja is bound to pay this much money, because in this whole transaction there was no consideration, and as such the transaction is not a legal agreement, it's a void agreement. Now let's see how the law defines consideration. This is section 2 clause D of the Contract Act, which gives us a detailed definition of consideration. And section says that when at the desire of the promisor, the other party, that promisee or any other person, has either done or abstained from doing something, or does or abstains from doing, or promises to do or abstain from doing something in future, this act or this abstinence, not doing something, or this promise of doing something in future is called a consideration for the promise. So very simple kind of idea. The consideration should be at the desire of promisor. It should come from promisee or any other person on behalf of promisee, and it should be in the form of something which has already been done or not done, or something which is being done or not done currently, or something which shall be done or shall not be done in future. These all are various forms of consideration. Now, there are various legal rules which a valid consideration is required to follow. In next few slides, we will be analyzing these legal rules which should be there in a valid consideration. The first legal rule is consideration may be past, it may be present, or it may be future. As we have seen in the definition given by section 2 clause D, that consideration may be something which has been already done or which is being doing presently, or it may be a promise to do something in future. So accordingly, consideration may be a past consideration, it may be a present consideration, or it may be a future consideration. Another very important rule related with the consideration, that law prescribes there has to be a consideration for the legal contract, but this consideration may or may not be an adequate consideration. It is not for the act to judge whether the consideration is adequate or not. What is required, that there has to be some consideration, otherwise it will be a void contract. But if the consideration is there and it is not an adequate consideration, it will not make any impact on the validity of that transaction or otherwise. Another rule related with consideration, that this consideration should move at the desire of the promisor. In any contract, one party is promising something to another and other is agreeing to pay some consideration for this. Now this consideration should be whatever has been demanded, what has been requested by the party on the first part. Any consideration which is not being requested by the promisor of the first promise, that consideration is not a legal consideration. Let's try to understand it by way of an example. Mr. X has constructed some shops at the request of district collector. Other party, Mr. Y, he has promised to pay rupees 1 lakh to Mr. X for this shop construction. Now, in respect of promise of Y, there is no consideration which is coming. Whatever X has done, that has been done at the request of district collector. For Y promise, there is no consideration in this case. And that's why now Mr. X cannot later on demand this rupees 1 lakh from Mr. Y, because there was no consideration in this particular transaction. Coming to the next rule of consideration, this consideration may be doing something or it may be not doing something. Both are valid consideration. Again, let's have an example. Mr. A borrows some money from Mr. B for a particular rate of interest. Then he fails to pay this money. Mr. B is now ready to file a court case and A says that I will pay you a higher rate of interest. Please don't file the court case. B getting agree to not file the court case is a valid consideration for A paying that higher rate of interest. B is not doing something in this case, and that is forming a consideration for whatever A is promising. So the consideration may be of doing something or it may be not doing something. Next, and a very important rule of consideration, that this consideration should be something which the promisor is not already bound to do. The person who is promising to pay something as a consideration, if he is already bound to do something, bound to do whatever he is promising as a consideration, then this will not be treated as a proper consideration in the eyes of law. Let's again try to understand this with an example. A client of a lawyer has promised to pay something extra to that lawyer if the lawyer wins the case. Now this promise of paying the extra money is without consideration, because the lawyer is already bound by the law to provide the best of the services and to see that his client wins the case. So in this case, whatever lawyer is doing, that cannot be treated as a proper consideration for that promise to pay extra money. One more very important rule related with consideration, that consideration must be real. It should not be imaginary. It should not be an illusionary consideration. It must have some values in the eyes of law. It has been held in various decisions that in following cases, there is no real consideration. If something to be done is physically impossible, if something to be done is legally impossible, or this consideration is something which is very, very uncertain, then all these will not be treated as valid consideration. Say for example, if somebody is promising to do something which is physically not possible, like say putting life into a dead body, this is a physically impossible kind of job and that cannot be treated as a valid consideration. Another example, A promises to pay 5,000 rupees to B and B agrees to get a driving license without a trial drive. Now this is legally not possible. You have to go for a trial drive whenever you want to get a driving license. So again, this is a legally impossible kind of work and that cannot be treated as a proper consideration. Example of uncertain consideration. One party is promising to pay a reasonable sum to another party. Now this reasonable sum is something which is uncertain, and that's why again this kind of promise cannot be treated as a valid consideration. So the idea is this: there has to be consideration, and this consideration must be a real consideration. It should not be imaginary, should not be illusionary. After discussing various rules related with the consideration, now we shall be discussing those agreements which are valid even without consideration. We have seen earlier that as a general rule, the agreement without consideration is not valid, but then law provides about certain agreements which are valid even though there is no consideration involved. Let's see which are these types of agreements. Agreements which are valid even if without consideration. The first is any agreement, any contract made on account of natural love and affection. Next one, any compensation for past voluntary services. Any promise to pay time-barred dates. Contract of agency. And finally, completed gifts. These are 5 agreements which are valid even if there is no consideration involved. In next few slides, we will be discussing each of these agreements in little bit detail. Section 25 subsection 1 of the Contract Act talks about those contracts which have been made on account of natural love and affection, and they are treated as a valid contract even if there is no consideration involved. The section provides that if any agreement is in writing and it has been registered under the applicable law, further it has been made on account of natural love and affection between those parties which are near relative to each other, if all these conditions are getting fulfilled, then this agreement is enforceable. It's a valid contract even if there is no consideration involved. The rule no consideration, no contract does not get applicable in this case. Now, the point is there are lot many conditions which are built into this particular section in order to create a valid contract. This agreement has to be in writing. This must be registered under the law. This must be made on account of natural love and affection, and the parties must be near relative. If all these conditions are getting fulfilled, then this becomes a contract which is enforceable even without consideration. Say for example, on a birthday party of son, his father promises to give him rupees 1 lakh. This promise is reduced into writing. It has been got registered also. Now it has become a valid contract, will become an enforceable contract in the eyes of law. Second type of contract which is valid even if without consideration, that is contract in the nature of completed gifts. Explanation to section 25 subsection 1 provides that if a contract is a completed gift, then this is a valid contract even if there is no consideration involved. There need not be natural love and affection or nearness of relationship between the parties. The gift must be complete, then only that will be a valid consideration. If it's only a promise for making a gift, then either it has to be covered under the earlier discussed section 25 subsection 1, or then it will get hit by the rule of without consideration contract is invalid. So the point is, if a gift has already been completed, then this becomes a valid contract, and later on any party to it cannot challenge it on the ground that there was no consideration involved. Transaction in this category is something what is called compensation for the past voluntary services. This gets applicable in a situation where a person has already voluntarily done something for another, and that other promises to compensate this first person for this thing which has been done earlier already. Now this promise becomes a binding promise, it becomes a valid contract, though for this promise to compensate now, there is no consideration involved. A very simple example should clarify the position. Mr. P finds a purse belonging to Mr. S, gives this purse to Mr. S. Now S promises to give ₹100 to Mr. P. Now this promise to give 100 rupees to Mr. P is a valid contract, and later on it cannot be challenged on the ground that there was no consideration involved for Mr. S. The consideration for Mr. S was something which has already been done by Mr. P, and it has been accepted by Mr. S that he will be compensating Mr. P for this thing which has already been done. Any promise to pay a date which has become time barred by the law of limitation, this promise is also a valid contract provided it has been reduced in writing. Now this promise is also without consideration, but still this will be treated as a valid promise, a valid contract. Similarly, in case of contract of agency also, no consideration is required. This has been provided in section 185 of the Contract Act. A contract of agency is a contract where consideration is not required. Now we would like to discuss one more very important aspect of Contract Act, that is whether a third party to an agreement can file a suit for the implementation of that particular contract. What is technically called is the doctrine of privity of contract, that is a person who is a stranger to an agreement, whether it can enforce the implementation of that particular agreement. This is what we will be discussing in next few slides. Now as a general rule, a contract creates rights and obligations only amongst those parties which are part of that contract. A third person cannot enforce the performance of the contract. This rule is called as doctrine of privity of contract. A person who is not a party to the contract shall neither have any rights into that contract nor shall have any obligation in that contract. The case has been discussed in quite detail in a very old decision, Dunlop Pneumatic Tyres Company Limited versus Selfridge and Company, where Dunlop Company has entered into a contract of sale of certain tires to P. The contract has provided that P shall not sell these tires below the list price provided by D. However, P has sold these tires to S, and S has resold these tires below the list price. The issue was this: whether the Dunlop Company can file any court case against S, whether Dunlop Company can restrain the S from selling these tires below the list price. Court has said that there was no contract between Dunlop Company and Mr. S. The contract of not selling the goods below the list price was between Dunlop and P. S was a stranger to this particular contract, and that's why he is not bound by anything which has been promised in the original contract. This is what is considered to be doctrine of privity of contract. Another example: A, who is indebted to B, he sells his property to C. C promises to pay off the debt to B. If C ultimately doesn't make a payment, whether B can claim this from Mr. C. It has been held that B cannot file a case against C because he is a stranger to the contract between A and C. Now, there are 5 exceptions to this doctrine of privity of contract. They are: in the case of a trust, in case of marriage, partition or other family settlement, in case of assignment of a contract, in case of acknowledgement or stupple by a third party, and in certain conditions which are running with land, this doctrine of privity of contract is not applicable. In next slides, we will be discussing about these exceptions in a bit detail. Is a case of a person in whose favor a trust or any other interest in some specific movable property has been created that benefits this contract even if he is not a party to the original contract. The next exception is in case of marriage, settlement, partition or some other these types of family arrangements where an arrangement has been made in connection with marriage of somebody or say partition of family or there is any other family arrangement, and in this case a provision has been made for the benefit of a particular person. That person for whose benefit the provision has been made in that particular arrangement, he or she may enforce that particular agreement even if he or she was not a party to that agreement. The next exception to the doctrine of privity of contract is assignment of a contract. Law says that when a contract has been assigned in favor of third party, the assignee of the rights and benefits can enforce that particular contract provided this contract does not involve personal skills. The next exception is in case of acknowledgement of what is called principle of stupple. It provides that where the promisor by his conduct acknowledges or otherwise constitutes as an agent of the third party, when a person conveys by his conduct the message that he is acting as agent of third party, a binding obligation is created in that situation. The last exception to this doctrine is the situation when there are conditions which are attached to certain land. Law provides that in case of transfer of any immovable property, the purchaser of the land who has the notice that owner of the land is bound by certain conditions created by an agreement and these conditions are affecting the land, the buyer shall also be bound by all those conditions even if he was not an agreement to the original agreement in which these conditions have been created. And now let's have a quick summary of whatever we have discussed about consideration. The very first thing, an agreement without consideration is void. The consideration may be past, it may be present, or it may be a future consideration. The consideration need not be adequate. It may be in the form of doing or in the form of not doing something. It should flow on the request of the promisor. It should not be something which the party is already bound to do. And it should be real, should not be uncertain or illusory consideration. There are certain contracts which are valid even if these contracts are without consideration. And finally, subject to certain exceptions, a person who is not a party to the contract cannot claim the enforcement of that contract. This completes our discussion about a very important element of contract, that is consideration. Thank you.